Hello, I'm Dottie Kay. Welcome to the 5th program on the law and your local government. This series is presented as a public service and is sponsored by the League of Women Voters of Upper St. Clair and Mr. Robert Hackett, attorney at law. The format consists of a lecture and general summary of each topic by Mr. Hackett, with league members leading discussion on the particular subject. Last time we looked at the fundamental land use control, and we continue with today's presentation, Zoning Law, What is the Game? Although the programs are taped, the discussion is unrehearsed and spontaneous. Here now to present the background information is Mr. Robert Hackett. He is the township's attorney and has been since 1975. He has lived in Upper St. Clair since 1960. He has offices in Upper St. Clair and is associated with the law firm of Strasburger McKenna in Pittsburgh, Pennsylvania. Mr. Hackett?
Today is the second session of our discussion of the zoning laws of Upper St. Clair Township. In the last session, we discussed the basic rules of zoning. Today, we're going to play a game called Name the Zoning Animal. We're going to name the zoning animal because if you misidentify the zoning animal, you can get bitten. Zoning animals bite developers, they bite townships, and they bite the neighbors. So I hope you'll play this game with me so that we can understand, and in as simple terms as possible, what zoning is all about. Zoning is so important to the people of the township. For example, in the last meeting, May 6, 1985, there were over 200 interested citizens attending a zoning hearing at the township. That number far exceeds any number we get for budget hearings or any other hearings. Therefore, isn't it true that you as citizens of the township should understand the zoning game? First of all, the most important zoning animal is rezoning. Rezoning means that the township institutes a process, or a developer institutes a process that changes the given zoning on any particular piece of land. When the zoning is changed, it of course changes the use of the land. And when you change the use of the land, you can totally change the structure or type of neighborhood. The important point to remember in rezoning is that only the legislators, the governing body, your elected commissioners, can change the zoning on a piece of property with very few exceptions, which we'll discuss later. The change in rezoning is the time that the township, its staff, and the people in the township express their desires on zoning. Because in most instances, whether zoning changes or not is totally discretionary within the elected officials of the township. To repeat that in another way, there is no law that requires rezoning in most instances. Therefore, there is no appeal by a person desiring rezoning to courts, as the rule is in all legislators that the failure of the legislator to pass or vote for a certain act is not appealable in courts. If the current Congress doesn't reform the tax bill, which is pending in Congress now, you can't go to court and appeal that. And so you can't go to court and appeal the lack of or the granting of a rezoning. However, there are certain exceptions to that. One is what we call invalid zoning, a sub-animal species of rezoning, and what we call spot zoning. In spot zoning, contrary to the animal game, we don't mean a spotted dog. We mean that you've taken a piece of land that is totally surrounded by other zoning and carved that spot out, illustrated this way. All of this land is zoned R1, let us say, for single family. If we went in here and zoned this little spot commercial, C for commercial, we would have spot zoning for that. Invalid zoning. Invalid zoning means that you can't confiscate a person's land by zoning. Let us use this example. If you owned a lot and you had Route 79 here, and let's say you had another interstate coming this way, and the township or another municipality zoned that intersection R1 for single family, you can see that almost nobody in his right mind would build a house at the corner of two interstate highways. Therefore, by creating R1 zoning in that situation, you have confiscated my land. You have created an invalid zoning because I can't use my land because I can't sell it for a single-family house in that situation. Both of those illustrations, spot zoning and invalid zoning, are aberrations of rezoning and are connected to rezoning. Now we must go into the more common animals in zoning. And first, let us take up the bottom listed, or the permitted use. The permitted use is a use which, when you come in and ask for a permit to build something or use something, the zoning ordinance inherently, within itself, permits the use without further hearings. So you should have a right, as a matter of law, to receive permission for a permitted use. There should be no hearing necessary. We have, though, two other kinds of permitted uses, two other sub-animals. One is the conditional use, and one is the special exception. In those two different names, we have special kinds of permitted uses. How are they special? A special exception is granted by the Zoning Hearing Board. Remember, in the last session we discussed that the Zoning Hearing Board was a quasi-judicial board. And here's an example of a special exception found in many communities. You can have a gas station in a commercial area if it meets certain criteria. For example, the gas station could not be within 500 feet of a school. The gas station would have to be 50 feet back from the right-of-way line of the street. And you might have other very specific qualifications to the gas station. The important point to remember, though, is this, that if the zoning ordinance permits a gas station by special exception before the Zoning Hearing Board, then if the applicant for the gas station is in fact 500 feet from a school, is in fact 50 feet back from the right-of-way line, and does in fact meet the other criteria, you can't refuse the applicant the right to use the gas station because you don't like it or because it creates more traffic. Because a special exception is a permitted use. And you, the township, passed the zoning ordinance allowing the special exception. Now we have a little rule for that, and here's the rule. If you zone a piece of land for a pig farm, you can't complain about the stink. That's the rule. If you zone any land for a certain use, you then can't complain if the person uses that land because the use will create traffic. That's very logical, isn't it? If you didn't want the traffic, the municipality should not have zoned it for that. Therefore, a special exception cannot be used as an excuse or a procedure to turn down something that is written in the ordinance as a special exception if the person meets the criteria for the special exception. That same rule applies to conditional uses. Exactly the same rule, except that conditional uses are granted by the governing body, that is, the commissioners in Upper St. Clair, rather than the zoning hearing board. But the law and the animal is exactly the same. We're going to move now to the discussion of another animal, non-conforming uses. The non-conforming use is a pesky little thing that many, many municipalities have problems with. And here's how we have a non-conforming use. In Upper St. Clair, the first real zoning ordinance was passed in about 1960, although there was some zoning before that. Let's say, for example, that in 1959, I got myself a nice junkyard right here in this little circle that we were talking about before, and we're going to call that our junkyard. Now, I'm operating the junkyard, and along comes a zoning ordinance, and it says, why, you can't have a junkyard there. But I already have my junkyard there. And therefore, you can't take my property and tell me to get rid of the junkyard because I was there before you were. In essence, I was there with the use before the zoning ordinance came along. So although all around this junkyard you may have very nice houses and you may have R1 zoning, you can't get rid of that junkyard, with one exception. There's a new case this year that says a municipality may do what they call amortize a non-conforming use. And sure enough, in Philadelphia, they had a law that said you can amortize an open-air non-conforming use. An open air would be one with no building. And you can make the person get rid of it in a reasonable amount of time. Therefore, we could say to this person that owns the junkyard, yes, it's true, you're legal because you were there before the zoning ordinance. But we're going to say to you that you only have 10 years to live, animal. And in 10 years, you have to close down your junkyard. This was held to be enforceable in 1984 by the courts of the Commonwealth of Pennsylvania. Now consider that. If a person has lived in the township for 40 years and has a gas station that's a non-conforming use and wants to pass that gas station down to his son or his daughter or his family, is it right for the township to say you can no longer have a gas station there? I'm not going to answer that. I'm just telling you the problem. That's the problem you have in non-conforming uses. Should you really get rid of them all, even if you can? It's a question that one has to think about and think of the whole philosophy of the township, and that, of course, is not up to me. That's up to the commissioners. That's why they're elected, and I'm appointed. Now let's look at one of the last animals for this session on zoning, the variance. The variance. What is a variance? Well, as you might think, a variance is a way of avoiding or changing the zoning ordinance for a specific case. Not a general change, but a case-by-case change. And remember, from our last session, we said that the Zoning Hearing Board is the board that grants variances. But when do you grant a variance? Let me give you some illustrations. I own a house. My father-in-law dies. My mother-in-law has to move in with me. We have 16 kids and 2 adults in the house, 4 dogs and 2 kittens. So we need another bedroom for the mother-in-law. If we build another bedroom, we can only build it on the back of the house, and if we build it, since the mother-in-law is rather large, we need a 20-foot by 15-foot bedroom. If we build it out 20 feet, it will go into the backyard area under the zoning ordinance. And therefore, we have what's called an encroachment into a building line. But this is really a hardship on us, because my wife has said to me, if my mother-in-law doesn't move in, she's leaving. Now, I come to the Zoning Hearing Board, and I say, we have to have the encroachment into the backyard line, as you can see, and I tell my sad story. Is that an unnecessary hardship? Well, it certainly is a hardship, but it's not a zoning unnecessary hardship. It's a sad tale, and you can't get a variance because of a personal hardship. And believe me, sometimes these are not funny. For instance, you may need a new room because someone is sick. You may need to expand your house for various personal reasons. That is not what the zoning law calls a hardship. The zoning law says that if the property, that is the physical design of the property, creates an unnecessary hardship, in that case, the Zoning Hearing Board can grant a zoning variance. Example, we have a lot here, okay? We have a building setback line of 50 feet from the road. 50 feet. Out here is the road, okay? It so happens that the back of this lot slopes down 30 to 40%. If we come back 50 feet, you can't build a house back here because it's too steep. A classic example of a variance. You then say, allow them to build the house with a 20-foot setback so that you can use your lot. Otherwise, you couldn't use your lot at all. And you place the house on here with a correctly granted variance. Too often, zoning hearing boards, ours included, treat variances as popularity contests. That's not correct. That's not what the law is. The law is very strict on whether or not you can get a variance for physical reasons. And it's important to the township that variances are granted with discrimination, because if you grant too many variances, you in effect don't have a zoning ordinance. You in effect don't have a nice place to live. And that's what we all want in Upper St. Clair.
Thank you, Mr. Hackett.
You're welcome, Dottie.
Now for the questions from our league members. To my left, we have Trudy Rose, Betty Sweeney, and Connie Harold.
You've told us rezoning is totally in the control of elected officials and therefore can't be appealed to the courts, except in the case of invalid and spot zoning. Does that mean that those two then can be appealed? And if they can be appealed, to whom could you appeal them?
Well, that's correct. The first statement you made is that generally a request for rezoning, being a legislative request, just the same as a request to cut taxes or raise taxes, is not an appealable situation. Therefore, there is no right of appeal from the decision of the governing body in Upper St. Clair, the commissioners, to the courts. And it would be to the Court of Common Pleas in Allegheny County in this particular case, in our case. However, what you said is correct. If you have an unusual situation in rezoning, for example, if the governing body rezones, but they are included in what is the doctrine of spot zoning, then what they've done is illegal. So they, being the landowner or neighbors or whoever has standing, could appeal that decision to the courts, and they would go to the Court of Common Pleas of Allegheny County. And the same concept applies to what in Pennsylvania is called invalidate zoning, which includes, by the way, our next program on exclusionary zoning, but also includes invalid zoning in the sense of zoning a piece of property so that it's impossible to use it, and thereby giving a cause of action to the owner, because in essence you've taken his property. Mm-hmm. You've condemned the property by doing that.
And so it's the Court of Common Pleas to whom you...
Of Allegheny County, that's right.
Thank you.
Suppose I have a large piece of property that is zoned for individual homes, but I've been unable to sell it for individual homes because of the steepness. How long would I have to try to sell it in that manner for that use before I could get it rezoned?
Well, that's a very good point to bring up, because that requires a lot of thought and a lot of facts in order to bring that fact situation that you're describing to the forefront and have action on it. Now, let's take your example. You have a very steep slope, and it's zoned R1 for single family. And the courts would go into how many years has it been that way? How much have you tried to sell it? Is it at all possible to use it for R1? And that would require testimony of real estate experts, real estate brokers, and so on. And if you could show that it's impossible to use your land and you've tried over a number of years for anything except, say, some type of commercial use, then you would have a right to either, number one, a use variance, or to have it rezoned. And it's a developing fact situation. There's no answer on a particular case, whether it would be you had to do it 5 years or 10 years or whatever. A good example of that in Upper St. Clair Township is the property where I have my office at Summerfield Commons. That was a zoned R1 for many, many years. However, as you know, Summerfield Commons is right between Route 19 and Old Washington Road. Well, would you like to build a single family in that 100-foot space? That's the question. And that's why the commissioners, after many years, did zone it so that you could put office buildings there, because they thought it was not usable for a single family.
So you're saying that they would consider it under invalid zoning, or it also could be considered under a variance?
That's right. That's right. You could go at it both ways. It's almost the same thing to develop the concept of invalid zoning. Invalid zoning in the whole area is called exclusionary zoning in one way or another. Invalid zoning for a particular piece is remedied by a use variance, but both of them are invalid zoning. One is kind of like a macro, in using the words of an economist, a macro invalid zoning and a micro invalid zoning.
In the category of permitted uses, how does a conditional use differ from a special exception? You gave us an example of a special exception. What would be an example of conditional use?
Well, there's no difference in the theory of conditional use and special exception. The only difference, Betty, is who grants it. In the conditional use situation, the governing body grants it, And in the special exception situation, the zoning hearing board grants it.
So it depends who you appeal to, is that it?
That's right. It depends. When you're writing your ordinance, what you normally do is you take little things. It's very logical. You take little things like swimming pools and tennis courts and things of that nature, and you make those special exceptions so you don't take up the time of the governing body. Whereas if you have things like shopping centers and things that affect the community in a more overall manner, you make them conditional uses. And the governing body takes that. Now, the zoning ordinance can be written either way. It can make everything a special exception. You don't have to have conditional uses. But in Upper St. Clair, the commissioners, I would say, have a very hands-on look at the community. They're very interested in making the community receptive to what they think makes the community a better community, and therefore there are many conditional uses that go before the governing body, and that's really quite unusual. Many communities don't have that kind of thing. The commissioners really don't take that much of an interest.
Thank you.
Bob, which of the zoning rules would apply if a citizen wanted to put a TV satellite dish on their property?
Well, that's funny that you asked that. Right now, we're looking at the whole TV satellite problem. We do have in our zoning ordinance provisions for antenna and provisions for radio towers. The provisions for what would be known as an antenna or a radio tower or a TV dish fall under the category of accessory uses. That's what really you're into. An accessory use is a subcategory of the principal use. So if you have a R1 lot where you can put a house, the principal use is the house. Then you can have various accessory uses, such as a doghouse, a fence, etc. And included in those accessory uses could be a radio and TV antenna. We are just developing now what are going to be the rules and regulations for satellite dishes.
I see. So am I given to understand correctly that if the citizen wanted to put a TV dish in his yard, he wouldn't have to come before the
Well,
board to get a
we
permit?
think they're covered to some extent by the definition of antenna and radio tower, but they're not covered as well as we want to cover them. So we are amending the ordinance to get in and have a whole separate category of what amounts to satellite dishes. And that's a good example of a developing ordinance. That's why your ordinance has to change, because you now have a whole new situation in the last year or so that you could conceivably have 3,000 dishes spring up. And you'd look all over the township and see nothing but dishes. Well, nobody wants that to happen. So how are you going to correct this, you see? And as a matter of fact, I think either in the very near future, they're going to have the TV dishes or satellite dishes, whatever you wish to call them, covered, and that will be covered under the category of accessory use.
Thank you.
You said that the law for non-conforming zoning had been changed. Say, going back to your example of the junkyard, say they told them it could exist for another 10 years.
Yes.
Within that 10-year period, could it be sold as a junkyard?
Yes.
And what about, even though they've said it can only last for 10 more years, it still could be
Yes,
sold?
you could sell it, but the person buying it, of course, would have to realize that it can be taken out of business in what amounts to a reasonable amount of time.
Right.
And that, therefore, of course, the value of what you're buying would be mighty limited. But that Philadelphia case that went into the amortization of the junkyard, incidentally, only covered an uncovered property. The put
Right.
it that way. It was only an open-air property. There is no case on if you'd have a building, whether you could amortize the building. Nobody knows whether you can do that or not yet.
I see. Has this law been changed in court?
Yes, it was changed in court. It was an interpretation of the state appellate court, which was new in Pennsylvania. Various states have held different ways in that particular question. Some states have said you can't do it, it's a taking of property, and other states have said, yes, you can do it, it's a valid police function. As you know, in America, there's always a dichotomy between whether you're taking a person's rights or whether it's a valid police function. And that's what we look at as the courts swing back and forth on many, many issues in American law. But this particular one has gone different ways in different states. And in the summer of '84 is the first time that was decided in Pennsylvania.
Bob, I have a series, it's sort of a statement of questions, and I'll go through the whole thing before you answer it. I suppose someone is handy, a citizen, and they decide to add a room which he can do without any professional help on his house. He does not bother to get a permit, but completes the room. What means does the township have for discovering this? Are there inspections, or does someone have to complain? What action is taken when the addition is discovered?
Well, first of all, we have a building inspector, a full-time building inspector, and that inspector moves throughout the township and is aided by the network of police patrols who use the radio if they're driving by a lot or by a property and there is new construction going on. They note that new construction, and then they check the records to see if that new construction has been issued a grading permit or a building permit or whatever it might be. So generally, the policing of it is a combination of the building inspector and other people patrolling the township. And that is how they find out. Now, assuming they have found out and that the person doesn't have a permit, then you can do a couple of things. Number one, you can cite the person for a violation of the ordinance and go down to the magistrate's office and have a hearing on whether or not the person has violated the ordinance. And if they have, they're fined. It's a summary offense, and it's a violation of an ordinance, and they're fined $200, $300 for the violation. And the second thing you can do is you can go into common pleas court and you can get an injunction which prevents the person from continuing, so that the common pleas court orders the person to A, stop building, or B, tear down the room. So you can do either one of those remedies the township can take, and we have taken those remedies and do so quite often. We've had two cases this year. One was the chicken case and one was the horse case. And we won them both so far. The horse case is in the Commonwealth Court, but it's a matter, we got an injunction that prevented someone from raising horses on property where they didn't have the required acreage to raise horses. And I think a township has to do that because, you see, you have to, it's like traffic policing. You have to show everyone that you're willing to enforce your ordinance or you lose credibility. And that's what the township does.
So anyone thinking of adding on a room themselves, it's wise to get a permit.
Yes, you have to.
Because they
If you're adding on a room or anything like that, you're involved in a structure, you're involved in building, so you have to go to the Department of Community Planning and ask them what to do and apply and get approval.
Yeah, it'd be a lot cheaper than having to tear it down once it's completed.
That's right.
Thank you, Bob. This concludes the 5th in the series, The Law and Local Government. Next time, our topic will be, Bob, would you like to tell us what the
Yes,
title-
next time we're going to talk about probably the most controversial zoning animal that strikes or bites communities, that is exclusionary zoning. The doctrine of exclusionary zoning is unique in Pennsylvania, and it is something that excites and upsets many citizens.
If you have program suggestions for the League of Women Voters, community information programming, please write League of Women Voters of Upper St. Clair, 171 Boxfield Road, Pittsburgh, 15241. For the League of Women Voters of Upper St. Clair, I'm Dottie Kay, and I want to thank Bob Hackett, attorney at law, and thank the panel members, Trudy Rose, Betty Sweeney, and Connie Harold. And thank you for being with us today.